Good day and welcome to the review of the Employee Privacy chapter, which is Chapter 18 in the SHRM Essential Guide to Employment Law by Charles Fleischer. As our text says, privacy is the right to be left alone. Invasions of privacy do not usually occur in the workplace because the location and the equipment belong to the employer. When someone is at work using the employer's equipment, they are supposed to be doing so for the employer's benefit. But we will discuss a few exceptions. Most of us would assume our pockets, wallets, and purses are private. If an employer intends to search such areas, there must be a compelling business reason and a written statement to employees. There is a lot of sensitive personal information about employees found in the workplace. Those may include results of medical exams, financial information, and information about mental disabilities. Employees expect such records to be kept confidential. Under the ADA, pre-employment examinations are generally prohibited, except for drug tests. Those records should be kept confidential if post-hiring medical exams are conducted. Substance abuse records can only be disclosed with patient consent. The Health Insurance Portability and Accountability Act, better known as HIPAA, also prohibits disclosing protected health information. Installing surveillance cameras at the workplace is allowed as long as there is a legitimate business reason. This does not include cameras in private areas such as the restrooms. Please read over the GPS tracking and electric monitoring sections. Those are found on pages 358 through 359. The Electronic Communications Privacy Act prohibits unauthorized access to stored communications, but things stored on the company email server, for example, would be an exception. Please read over the Bring Your Own Device policies that are found on page 362. For the most part, the Employee Polygraph Protection Act prohibits employers from using lie detector tests. Our text does list some exceptions on pages 363 to 364. Drug and alcohol testing is standard in many workplaces. Employers want to maintain a drug and alcohol-free workplace, and they are concerned with safety. Some employees, however, object to testing procedures. Remember, a person with an addiction would fall within the ADA provisions. Please read over page 365 of tests that an employer may give. The Department of Transportation oversees the transportation industry. Covered employees are subject to drug and alcohol tests. Please review the section for information on reasons that the DOT can require testing. Testing for marijuana use is problematic in the workplace. Unlike alcohol testing, there is not a test that shows impairment from marijuana. Also, a positive urine test does not confirm current use, as it may take a month or more to get a negative test. Employers should consider the state laws about marijuana use when creating policies. Regarding employee mail, federal law prohibits obstruction of mail correspondence. Figure 18.3 shows suggested employee handbook information. Please review the sections dealing with social media, criminal records, and driving records, and those sections are found on pages 370 to 373. Our chapter concludes with a section called Identity Theft. One of the top causes of the theft of records are from employers or other businesses. There is a list on pages 374 to 375 of ways to avoid identity theft of employees. This concludes the review of the Employee Privacy chapter. Have a great day.